Morning, everyone, and welcome to the Utah Court of Appeals in virtual session. Let me introduce the panel this morning. I'm Greg. I'm joined by Judge David Morton and Judge Ryan Harris. And if counsel would be so kind as to state their appearance on the record.
Yes, this is Attorney Gregory Scalen for the appellant Jacqueline Calsert.
I am Matthew Flores on behalf of the estate in this matter.
Excellent. Aside from my little glitch this morning, we have it down, but there are a couple from my
Judge Orm, I can't hear you. I can hardly hear you at all.
About
It does keep on cutting out on my end as well.
you know what?
Mine too. Mine too. I think you have sound on both your phone and your, yeah.
How about that? Is this better?
Much.
That does sound better.
Oh, what I did was abandon the computer part of it and go straight to my iPhone. It's not terribly important. We are able to see each other so long we can hear each other. Everyone can hear me now reasonably clearly.
Yes, Your Honor.
Excellent. Well, I apologize for that hitch. Part of my prepared remarks include, we may encounter problems, you will be patiently through them. So hopefully we will
Your
have
Honor,
additional.
it's still cutting out. I'm sorry.
Yeah.
I can't hear it.
Okay, here's what I'm going to do. Since I can hear you all loud and clear, let me ask Judge Morton to take over as the chair and make the announcements. Did you get that word, Judge Morton?
I did, and I'll be happy to fill in.
Thank you.
I think we've got the appearance of counsel on the record. What we're hearing today is Calsert versus Flores. It's our court case number is 2018-1061. Pursuant to the Chief Justice's administrative order, we're conducting our arguments today remotely so that we can continue our critical work of the judiciary. We appreciate counsel being patient with us. I assume since you're not interrupting me that you're hearing me okay. Is that right?
Yes,
It's
Your Honor.
better, Your Honor.
Very good. We're going to ask you to do a couple of things. One is when it's kind of virtually when you're at the lectern, so to speak, then we'll be listening to you and you can leave your video and your microphone active. Would ask you to mute both of those when you're not arguing to save on bandwidth and also that we can focus our attention at the lawyer who's literally at the lectern, just like it would be in court. Now, it can be a little different when we ask questions. As you know, we're a little bit used to interrupting at our pleasure. We're going to do that a little bit differently. We'll interrupt you as per normal, but we also might wave our hand to let you visually know that we have a question. And Judge Orm, just so you know, we do see you on your phone. There's a hand. So watch for that. Just so you know, we won't be as critically or as critical on our time management as we might be, just because we know sometimes these technical circumstances can require that we kind of work around that. Obviously, if there's any pending questions, you can feel free to answer those before we begin. So do you have any questions before we proceed?
No, Your Honor.
No, Your Honor.
Very good. Then we will entertain Mr. Scalen's arguments first. And Mr. Flores, if you'd mute, we'll see you when it's your turn.
Your Honor, this is Attorney Gregory Scaven. I represent the appellant in this matter, Jacqueline Calsert. Your Honor, the last couple of days I've gone through my appellant's brief along with the reply brief. I've come to the conclusion that I believe everything is really contained in my brief. I could give a rendition of for Your Honors right now, but it would just be another rendition of what's in the appellate brief. And I've also had an opportunity to look at the case law. I also felt that the case law is pretty much set forth. So at this point, I would ask if Your Honors had any questions they want to ask me. I believe all my arguments are properly set forth in my brief. Yes, Judge Orem.
I have one.
Yes.
I follow the scenario you outline in your brief and the logic of your argument with one substantial question, and that is why, if your client was of the view that she was divorced at some point in 1995 and free to marry her late common law husband, as she sees it, why in 2005 was she moved to file another divorce complaint?
You know, that's been a question that's been raised. She doesn't recall this filing a second action. I've asked her about this. She simply just doesn't recall. The divorce was a very traumatic for her. This was a case that was involved with her where her husband was involved in some sexual abuse of the children. So she went through a great deal of trauma, and so I think that's one of the reasons that she just didn't face what she should have faced with these two divorces. But in answer to your question, she doesn't know, and she doesn't recall.
But there's not a suggestion, for instance, that well-intentioned but unauthorized counsel took it upon himself to file such a complaint without any knowledge on her part. She just totally doesn't remember.
She just doesn't recall it. And as I recall, I don't recall who was counsel on the second divorce action, but I believe the counsel on the second divorce action dropped the ball and was eventually, I believe, disbarred. Other questions, Your Honor? Yes, Judge Harris.
Yeah, thank you, Mr. Scabelin. I'm interested in your response to the final argument made in the red brief. The argument that basically says, hey, look, even if the nunc-pro-tunc order is valid, there's this case, White versus Blair, that talks about how the language in the case says a common law marriage must take place immediately or not at all, and that a relationship illicit in its inception is presumed to be illicit throughout the period of cohabitation. I just wonder if I have your complete response to that case and what you think those words mean.
You know what? I have some real difficulty with that also. But I look into what happened in this particular matter and what the statute is on these nunc-pro-tunc divorces. The reality is if you have a court enter a order that says that this divorce is nunc-pro-tunc to a previous time, that's the order of the court, and what we had is a final order of the court in this matter.
Yeah, I understand that. I think the argument made by the other side is that you allege that this relationship between your client and Mr. Flores began sometime in 1994.
That's correct.
And I think that the other side is interpreting this case as saying, look, if the common law marriage couldn't begin in 1994, then it could never have begun. I think that's the way they're interpreting that language, and I guess I wonder if that's the way that language ought to be interpreted, or if you have any other response to that.
Well, you could say that about just about every case. There's purposes behind the non-proton provision. I think one of the main reasons why the courts the legislature implemented the non-proton provision was for those very reasons. People thought they were divorced and then were getting married to second people. That happened here in the first district many, many years ago. There was a number of people who thought they were divorced, and then they went and got married to somebody else. And so the only thing they could do is make the previous divorce have it a non-proton to avoid that very situation. So I think that's one of the purposes behind it.
All right, thank you.
Anyone else?
Yeah, let me ask a different question. So your proposed resolution here is for us to do exactly what? I'm thinking it is for us to reverse the order dismissing the case and send it back for further proceedings at which your client's actual intent, knowledge, level of consent can be explored in a more fulsome way. Do I understand that right?
Absolutely, absolutely. A Rule 12b-6 is a very difficult motion. The last few days I've been researching, and we're on the federal level, and it appears to me that they're really starting to push against that because they've had some unsavory results from these 12b-6s that have occurred. And all my client is asking is we can, if that's an argument, then we can ferret that out on the district court level. I just don't think it was appropriate to dismiss it at this level.
In other words, building on Judge Orm's question about your client's knowledge of the 2005 divorce filing, she has put an affidavit in the record now indicating that she thought she was divorced all the way back in 1995.
That's
correct?
true. That's true. And also her former husband believed that also. He thought he was divorced.
And I suppose your position would be that at this point in the proceeding, given the procedural posture, we I guess have to take that as true until summary judgment or until trial, until there's a factual finding made that it isn't?
Well, this case was a 12b-6 motion. This wasn't a summary judgment motion. And so you take the four corners of the document itself, that being her petition to recognize the marriage, and to take that as true. And so, yes, I think that's what the court needs to do is take that as true. I don't think the court had the authority or the right to go ahead and do what it did and take judicial notice of the documents from her two previous divorce proceedings.
Well, on that point, I guess even if taking judicial notice of those proceedings was okay, well, I mean, let me ask you this way. Do you think that's a dispositive, right? If we determine that the court was within its discretion to take judicial notice of those two divorce files, would your client lose if we determined that?
Well, you got some other factors that are going on with. I'm applying the general rules that this court has applied on other proceedings, and also what was your question again? I'm sorry.
My question is, if we were to determine that the red brief was correct,
okay,
and the district court was correct in that it was okay for the district court to take judicial notice of these two divorce files, one from 1995 and one from 2005, and look at those dockets and see what was in them. If we determine that it was okay for the district court to do that, can your client still prevail in this appeal?
I think so, because of the way that the district court did it in this particular circumstances. They didn't apply it. If they properly took judicial notice, they didn't apply the documents that they took judicial notice in correctly. As the brief outlines, and that being my blue brief outlines, the district judge in this particular matter looked at some of the facts, took a preponderance of the evidence standard, which I think is inappropriate, and applied those facts to his own way of looking at things, which I think was inappropriate. I think when you take judicial notice, you take the documents for what they are. You don't change their meanings as was done in this particular circumstance, and you take the documents as they are. And not only that, I was looking at some of the standards that are set forth and on the federal level, and when you look under Rule 201 of the Utah Rules of Evidence, you just don't look at the documents. You have to look at and determine whether they've ever and analyze them to determine if they were ever in dispute. So not only do you not have to look at the documents and take them at face value, but you have to also determine where those documents were ever in dispute.
All right, thank you.
Anyone else? Okay, thank you.
We'll give you your full time on a rebuttal, and Mr. Lortz, if you'd like to address this now.
Good morning, Your Honors. Thank you for the opportunity to address the court today. Your Honor, our position is that Ms. Calsert's petition in this case was properly dismissed for failure to state a claim. In reaching the decision, Judge Wilmore properly relied on public records that showed that Ms. Calsert was married to Michael Wayne Calsert during the entire relationship that she had with Mr. Ventura, making her incapable of entering into a common law marriage. Ms. Calsert's attempt, yes, Your Honor.
Let me just jump right in there, Mr. Lors, if I may.
Sure.
Didn't the nunc pro tunc order make her legally capable?
Your Honor, the nunc pro tunc order in this case is not valid. Judge Wilmore correctly rejected Ms. Calsert's attempt to rewrite the past and to rewrite really what the public record shows really occurred. Yes, Your Honor.
And this is where I'm really struggling with your position here, Mr. Lors, is how Judge Wilmore had the authority to declare Judge Allen's order invalid and not enforceable. He actually goes to the length of saying that Judge Allen erred. And I wonder how one district court judge in a separate case, and I'm aware of the building case, that was my case on the district court level, I'm very familiar with that case, when one district court judge takes over for another and continues to manage the same case number, that new judge can go back if the orders aren't final and rethink some of the things the previous judge did. I get that. But here we have two different case numbers, one managed by Judge Allen and one managed by Judge Wilmore, and I'm struggling how Judge Wilmore considered it okay for one district judge in another case to sort of jump in and review the work and determine that the other district judge erred, and to declare that other district judge's order invalid and unenforceable. Can you help me with that?
Yes, Your Honor. I mean, the purpose of equity in courts is to try and do justice to the parties that are before the court. Now, Judge Wilmore, he was the judge of the 2005 divorce proceedings, and he's actually the judge that signed the dismissal when she filed for that divorce in 2005. You also have Judge Wilmore, who is the judge that's presiding over the probate in this case, and he's the judge that's also presiding over this petition to recognize the common law marriage. And so when a pleading is filed in this case that says, I was capable of entering into a marriage on this date, and yet we show the court those public records that show that that's not true, I don't think that in the interest of justice, Judge Wilmore just needs to sit back and say, well, I'm not going to consider that as it relates to the parties properly before me. When I presided over the 2005 divorce case, I'm presiding over the parties right now, and I'm also presiding over the probate case.
Well, the implications of your argument are a little bit concerning to me. That it seems like if Judge Wilmore can ignore Judge Allen's order in this instance, what's to stop a district judge from ignoring another district judge's order in any other instance? I mean, I'm having a hard time seeing why You know, if we say it's okay for Judge Wilmore here to second guess Judge Allen in a different case, wouldn't we open the door to allow district judges to second guess each other in different cases, sort of in other situations too?
Well, I think that the equities in this case, Your Honor, I think that it was proper for Judge Wilmore to do so. As soon as when the petitioner filed the petition asking the court to recognize the common law marriage, there was no nunc-pro-tunc order at that time. She filed the paperwork in March, and unbeknownst to Judge Wilmore and unbeknownst to the estate, she was going, without notifying us, she was trying to get that other paperwork done. And so I think Judge Wilmore recognized that. When that came to the court's knowledge during a probate hearing, then he immediately had even that case, even the 1995 divorce case, transferred to him, so that he was actually presiding over all of them at the same time. And I think I think that's appropriate in this case. I don't think that it would be wise or public policy having allowing a petitioner to state one thing that's clearly contradicted in a public record, and to say that Judge Wilmore just has to sit back and accept what happened by Judge Allen. I don't think that is proper. Yes, Your Honor.
Are you saying that the nunc-pro-tunc order has been set aside?
There's no order of Judge Wilmore actually setting aside the nunc-pro-tunc order.
Because he can, even if he assigned that case to himself, you don't think he could actually set it aside without somehow bringing husband number one back into the proceeding, could he?
I believe that, yeah, that he would need to do and go through additional steps if he was going to formally set that aside. The way that I take it is, what he's saying is, I'm not going to allow the nunc-pro-tunc order to be enforced as it relates to the parties that he's dealing with before the court.
Do you have any case that you can point to that is a corollary to a court doing that? Not leaving an order as is, not having it be set aside, and declaring it ineffective?
I do not have a case directly on point with that, Your Honor.
Do you mind if I change? Oh, go ahead, Judge Orm. Judge Orm, you're muted.
Yeah, we can't hear you.
How about now?
Yes, Your Honor.
Okay.
Yes.
I have a question that pertains to this general subject. I am perhaps conceptually a little less concerned than Judge Harris about the ability, in an appropriate case, one district court judge to beg to differ with another when there is a rather different question at hand. But I very much take Mr. Scablin's point that when taking judicial note, any judge is sort of bound to accept the documents at their face value. So I very much understand Judge Wilmer's concern when he takes judicial notice of a nunc-pro-tunc order, he takes judicial notice of a divorce complaint filed 10 years later and dismissed for lack of service. Something is going on. But I question whether or not he at that point can simply declare that the 2005 action necessarily trumps or invalidates the nunc-pro-tunc order and move on with things. It seems like that might be the occasion for an evidentiary hearing. Something screwy is going to be sure. But does he not perhaps go too far in just straightening that all out in a way that strikes him as being logical without taking testimony from the affected parties, without getting some actual evidence on how did we end up in strange place?
So, Your Honor, yeah, I think that the court could, and looking back, we could actually have additional hearings. But at the end of the day, the non-proton order in this case does not matter. I mean, even if you accept as true the assertion that was put in the petition, she claims that she entered into this common law marriage prior, a year and a half prior to when the non-proton order actually takes place. And so even with that non-proton order, the time that she claims that she enters into this common law marriage, she was prohibited. She was married at that time to Michael Wayne Calsert, and no divorce had been granted under the Utah statutes. That's still prohibited.
So on that point, Mr. Lors, I guess you're talking about the language in White versus Blair that says a common law marriage has to take place immediately or not at all?
Yes, Your Honor. That is what the White v. Blair case states. That
I guess I'm wondering. I asked this question to Mr. Scablin, but I don't know exactly what that language means. If you look at the case cited by White there, that Murnian case out of Montana, I don't know if you've read that one. That case goes directly against the language, the reading of that language you're advancing. In that case, the parties entered into a relationship in Washington where common law marriage is not even legal at all. Then they moved to Montana at a later date, and the Montana court said, yeah, that's fine. We're just going to recognize the common law marriage as of the date they moved to Montana, even though the relationship was not able to be come to fruition at the time they started it. So I guess I wonder what that language actually does mean, given the background there.
Well, I think, Your Honor, that the courts, in general, the courts they recognize the sanctity of marriage and that it should be done in order and process. That is a presumption that's stated by the White v. Blair case. I think that under specific facts, maybe that presumption could be overcome, but not based on the facts that we have in this case. Because the facts that we have in this case is in 1995, based on the public records, she's filed for divorce, but then it's being continued without date. And then in 2005, she's again filing for divorce, and that again is dismissed. The only reasonable inference from that is that for whatever reason, Ms. Calsert sought a divorce, changed her mind, and the case was dismissed. That's the reasonable presumption, or the reasonable inference from the facts in this case.
Well, let me raise a hypothetical then. Let's assume somebody in 1995 thinks they're divorced. They sign some settlement papers, and the documents just don't get filed. And in 1996, based on that belief, they go ahead and get married to somebody else, right? Then in 2005, they figure out, oh no, something happened. My papers didn't get signed. I thought they had. And they go in and file another case to indicate that, to try to fix that problem. Under that hypothetical, the filing of the 2005 case wouldn't necessarily be inconsistent with a belief that somebody's belief that they were divorced as of 1995, would it?
I believe that there could be scenarios where you could get around that, that language that we've talked about. But in this case, those aren't the facts. It has to be a reasonable inference. And even if Ms. Calsert reasonably believed that she was divorced in 1995, at some point, that reasonable belief became unreasonable. Hence, she filed for the divorce in 2005. And so she can't claim, at least in 2005, that I reasonably believe I'm divorced if I'm filing another divorce action. And it's a judicial notice to the court that I'm married and I'm trying to seek a divorce.
I'm sorry for so many questions, Mr. Lors, but I have another. I'm struggling with a court reaching sort of the reasonableness of somebody's belief or the reasonableness of an inference in the context of a 12b6 motion. Can you help me with that?
Well, sure. Under the 12b standard, they do admit the facts in the complaint, but challenges the right to relief. But should a court grant them, they should grant a motion to dismiss, though, when assuming the truth of the allegations in the complaint and drawing all reasonable inferences therefrom. There still has to be reasonable inferences from the facts that are alleged in the petition. And the court does not need to accept extrinsic facts or legal conclusions as well. And if you look at this case, the only fact in the petition that is contradicted by the public record appears in paragraph 6 of her petition, wherein she states that I was legally capable of entering into a solemnized marriage. That's not really a fact. That is just her own legal conclusion. And that's a legal conclusion that is directly contradicted by the public record and the fact that she was married at all times relevant to Mr. Calsert.
Before you sit down, Mr. Flores, I know your time is getting short, but can I ask you to talk about your Rule 60D argument? That argument seems to make some sense to me in that you can, or at least maybe can, I don't know, in this case you can, but generically, Rule 60D does seem to allow people to file an independent action to ask a court to set aside a judgment that's been previously entered. And I get that that's an available option here, but after looking at the record in this case, which, you know, there's only about 200 and some odd pages in this record, it's not very long. I was unable to find any place in the proceedings below where your side raised that issue, or your side invoked Rule 60D, or let Judge Wilmore know that that's what you were asking him to do. In other words, that you were asking him to invoke Rule 60D to set aside the previous order. Can you point me to any place in the record, maybe I missed it, where Rule 60D was invoked in front of Judge Wilmore?
Your Honor, you're correct. We did not explicitly reference Rule 60D in our motion. But what we did do is we did ask the court in our motion to dismiss, based on the same reasoning that applies to the Rule 60D. We did ask the court to not consider the non-proton provision. That was part of our motion to dismiss, as well as our reply brief. And so we put that issue to the court. But yes, we would ask the court, and I know that we would be looking for the court to look at the substance rather than the form, because we did not explicitly refer to Rule 60D.
Our case law is pretty consistent, though. A motion isn't the initiation of an action, right?
Yes, Your Honor.
So how could even if it was implicit that your theory was consistent with Rule 60D, how does raising this in a motion constitute the initiation of an action, an independent action under Rule 60D?
And that's where our argument is. We would ask the court to interpret the petition that was filed in this case to consider that under the equities as the independent action for those purposes, and then to allow it to be brought by our, we've cited to the court cases from other jurisdictions where they've allowed the independent action to be raised as part of a counterclaim or as part of a defense. Rule 60 also allows by motion, though, as well. And we did file a motion, although we did not explicitly refer to that language.
Can I ask you mechanically an additional question concerning judicial notice? I suppose if you have a trial court take judicial notice that on a given date back in history it was a Tuesday versus a Wednesday, that's something that we as an appellate court can independently verify. However, when you take judicial notice of a public record, is there any requirement, or is it important that the trial court put in the record, the public record, that it's taking judicial notice of?
I believe that it could be important to the extent a judge relies on anything in the public record. Then, yeah, it probably should. In this case, what we had filed with the court and what we had supplied to the court were the dockets themselves. Those were included as exhibits to our motion to dismiss. And that's what we'd ask the court to take judicial notice of.
So the docket entry is not the actual pleadings?
Your Honor, right, we didn't have access to the actual pleadings themselves because we're not a party, we're not counsel for either the petitioner for the divorce or the respondent. And so we had attached the docket themselves and asked the court to look at those entries within the docket.
Does that make it even more important than if the court takes that step and says, yeah, I'm going to go look in a private, what's been designated as a private filing, that the court then actually copy and insert into the record the thing that they're now, for our purposes, we have to decide whether it was properly or not properly taken judicial notice of?
Well, I don't think that Judge Wilmore's determination hinges on what was in one of those documents. I think that can be made by just looking at the dockets themselves. I understand that he pointed out that she had stated within a pleading that that she claimed that she thought that she was divorced as of 1995. Ms. Calsert never made that part of the proceedings. She never put that in the petition herself or anything like that. So I don't think that he even needed to consider that statement itself. The record, the public docket itself is sufficient to show that she was married, she did not obtain a divorce in either 1995 or 2006, and that she was married throughout the duration of her relationship with Mr. Ventura.
Well, all righty. We appreciate you answering our questions. Any other questions from the panel before I turn the time back over to the panel? Seeing none, thank you for
your time.
Turn back to Mr. Scabelin.
Can you hear me? Can you hear me?
Yes.
Okay, thank you. Just a couple of things. I think it's interesting to note that something's been lost in a lot of this is what husband number one. Husband number one thought that he was divorced. He always believed he was divorced. Two, where the counsel talks about a lot of the equities and the equities that should be done in this case. Well, my understanding in the reading of Rule 12b-6, any equity or inferences are in favor of the non-moving party, and so any inferences should be applied to Ms. Calsert. And three, I got the impression from counsel that the district court should have just looked at the dockets themselves, but that's not what happened in this case, as the records clearly states. Judge Wilmore, or the district judge, went into the cases themselves and reviewed the documents themselves. Any questions?
I see nobody entering or waving their hand, so I don't think so.
So guess what, Your Honor? I appreciate it. Hopefully I will have been helpful, and thank you.
All right, then. We appreciate, counsel, all of your arguments today and your briefs. We will take this matter under advisement and issue a written decision in due course. We appreciate your ability to accommodate us under these circumstances, and for the most part, I think everything went off without a hitch, and so we wish you a good day, and we'll probably see you later in similar circumstances. I don't think we'll be ending this anytime soon, so thank you.
Thank you.